This has been such a great collaboration that we've had with the Jackson Center, the Chautauqua Institution, ASIL, the Harris Institute, and Syracuse University. And we've had a number of teleconferences over the last few months as we put together this program. And I have to tell you, I do a lot of these conferences, and sometimes they don't go that smoothly, and this was always a pleasure to get on those calls. This is a really collegial, good group, and I hope we can work together much more in the future. On one of those calls, we were discussing who would get to introduce whom during the program, and the prospect of introducing Juan Mendez was on the table, and I jumped at it. Because I started my international legal career at Human Rights Watch. And unfortunately for me, I did not really overlap with Juan at Human Rights Watch, where he spent 15 years. But his ghost was in the place. And his tenure there was the stuff of lore. And every time it seemed I asked someone, why do we take this policy position, or why are we advocating this in this context, people would say, well, Juan developed that policy, or that's what Juan said, or Juan did it that way. And it was my regret that we didn't get to work together, and I'm pleased that we can now cross paths here. Juan is currently the president of the International Center for Transitional Justice in New York, a relatively new organization, but has quickly become really the preeminent non-governmental organization working in this field. Doing research, analysis of what works in transitional justice, and very effective advocacy on those issues. He has also, while serving in this position for the last 3 years, been the special advisor to the Secretary General of the UN on the prevention of genocide. Before taking on those positions, Juan worked for 15 years at Human Rights Watch, where he was the director of America's Watch and then general counsel. He served from 1996 to 1999 as executive director of the Inter-American Institute of Human Rights in Costa Rica. And between 1999 and 2004, he was a professor at Notre Dame and director of the Center for Civil and Human Rights at the university there. Between 2000 and 2003, he was a member of the Inter-American Commission on Human Rights of the Organization of American States and served as its president in 2002. He's taught at Georgetown and at Johns Hopkins, and teaches regularly in the Oxford Master's Program. It's really hard to think of someone who has done more to advance human rights in the Americas, certainly in the last 3 decades. And not only has Juan been a tireless advocate for this cause, but he has done so at great personal cost. In the early part of his career, he, as a result of his legal work on behalf of prisoners of conscience and political prisoners in Argentina, his native country, he was arrested and subjected to torture and administrative detention for 1.5 years. Amnesty International during that period adopted him as a prisoner of conscience. So we have here tonight with us someone who knows a great deal about our subject, is an expert in the field, and has lived our cause. And so it's a great privilege to have Juan Mendez with us, and please join me in welcoming him to our podium.
Thank you very much, Betsy, for that very warm introduction. It shows that when you work in human rights, you make very good friends, and that explains the warmth and the exaggeration in some of the words that Betsy has just said. I have to say that I'm very humbled to be here in the presence of Nuremberg prosecutors, but also in the presence of current-day prosecutors who are doing the work of breaking the cycle of impunity. That is my main concern at the International Center for Transitional Justice, and it's a big honor for me to be invited to speak to you, but it's a big honor for all my colleagues at ICTJ that you have asked me to render these remarks. I'm very grateful to the American Society of International Law, to the Robert Jackson Center, to the Chautauqua Institution, to Syracuse University, to the Whitney Harris Center at Washington University in St. Louis, and to the Planet Hood Foundation for this opportunity to speak at this very important dialogue. It's a great pleasure to be here tonight in front of all of you. My presentation concentrates on the importance of the prevention of mass violence and international crimes, including war crimes, and I will do so mainly from the perspective of the programs that the International Center for Transitional Justice carries on in several countries, but also from my recent experience as the former Special Advisor to the Secretary General of the United Nations on the prevention of genocide. Breaking impunity and fostering accountability is a crucial component in the prevention of future violence and mass atrocities. No prevention efforts can take place without a serious attempt to break the cycle of impunity for past human rights violations, especially if they are so widespread or systematic as to constitute war crimes, crimes against humanity, or genocide. The failure to do justice to the victims can lead to the desire to obtain revenge, and thus to more crimes. Accountability is essential to halt the vicious cycle of revenge, to enable the victims, their families, and communities to live peacefully with the communities that the perpetrators of atrocities claim to represent, and ultimately to avoid blaming the descendants for the crimes committed in earlier generations but by those claiming to represent certain communities. Accountability for such crimes must be comprehensive, balanced, and holistic, meaning that policies and practice must address the need to discover and disclose the truth, to bring perpetrators to justice, to offer reparations to the victims, and to promote deep reform in the institutions through which state power is exercised. While criminal prosecutions should not be the sole response to impunity, there is no doubt that they must play a central, indispensable role in any policy of accountability. Prosecutions also represent the state's fundamental obligation to give victims access to justice. In addition, concerning international crimes, states have a clear international legal obligation to ensure that justice is done. This is particularly the case for serious violations of international humanitarian law. For war crimes, international humanitarian law, as defined notably in the Geneva Conventions and their additional protocols, establishes a duty for states to prosecute and punish those responsible or to hand them over to be prosecuted by another state party under the audedere aut judicare principle. As such, in the late 1940s, international humanitarian law created a new set of obligations, which in turn paved the way for the enforcement of these norms. Therefore, to fully foster accountability for such crimes, a dual approach should be favored. On the one hand, the international community must pay more attention to helping states live up to this obligation by building independent, impartial judiciaries that can prosecute mass atrocities with full respect for due process of law and fair trial guarantees. On the other hand, our support of the role of the International Criminal Court and other international or hybrid criminal jurisdictions must also be oriented towards supplementing the absence of will or capacity to produce fair trials domestically, but also to help generate that capacity in the future. This year we celebrate the 100th anniversary of the 1907 Hague Rules, as well as the 30th anniversary of the 1977 additional protocols to the Geneva Conventions. In the 70 years which elapsed between those two dates, 1907 and 1977, the world suffered 2 world wars, the Holocaust and other genocides, and many, many terrible war crimes. But these years have also marked the codification of the body of international humanitarian law, the materialization of the principle of individual criminal responsibility at the international level, and the strengthening of all forms of accountability for these crimes. The near universal ratification of the Geneva Conventions, as well as the recognition that many of their key provisions have acquired the status of customary international law, bears witness to this reinforcement of international law, and in particular of international humanitarian law. If we only just look back to less than 15 years ago, we see how far we have come from the pervasiveness of impunity for grave human rights crimes and from the permissive attitude towards that impunity by the international community. Many of you present here tonight have personally and professionally played a big part in these developments. Since 1993, we have notably witnessed the establishment of the international criminal tribunals for the former Yugoslavia and for Rwanda, of the Special Court for Sierra Leone, of the extraordinary chambers in the courts of Cambodia, and of other hybrid mechanisms in East Timor, Bosnia-Herzegovina, Kosovo, and recently Lebanon and Guatemala. Important too are efforts to prosecute these crimes at the domestic level, in places like Argentina, Chile, Peru, Colombia, Rwanda, and Ethiopia. The creation of the International Criminal Court in 1998 was the high point of this evolution, signaling that accountability for war crimes, crimes against humanity, and genocide is now paramount. But the Rome Statute is not only the culmination of a clear historical trend, it is also the means to establish an instrument that makes justice possible, even when the national domestic jurisdictions are unable or unwilling to afford it. And yet, for each situation in which the ICC has acquired jurisdiction, we hear voices calling for amnesty, withdrawal of indictments, or other forms of exercising discretion and avoiding prosecutions, supposedly in the name of peace. With the best of intentions, some are urging measures that implicitly give in to the blackmail of the parties to the armed conflict. Peace can only come if those accused of atrocities are given guarantees that they will not be touched. We are concerned by the revival of this debate that some of us had hoped was more settled by now. To those who have followed the evolution of human rights in the last 25 years, the debate rings of earlier discussions as to whether fragile democracies could really afford to investigate and disclose, let alone prosecute, the major crimes of the preceding era. The alleged antinomy between justice and democracy, often rephrased today as a tension between peace and justice, is debated among academic circles and also among practitioners. A major conference was recently co-organized in Nuremberg by the ICTJ, with others, to discuss this tension and to explore possible ways in which peace and justice indeed can be mutually reinforcing. In northern Uganda, while there is a broad recognition that the ICC arrest warrants have assisted in bringing the LRA to the negotiating table, some have portrayed those warrants as obstacles to progressing further with the peace process. We believe, however, that the warrants act as an incentive to keeping the LRA involved in the peace talks. We also welcome the signature of an agreement on accountability and reconciliation between the LRA and the government of Uganda that was signed on 29 June of this year. The agreement proposes that Uganda should implement its international obligations to prosecute senior leaders of the LRA under national law. Depending on what is proposed and implemented, we believe this may be consistent with the Rome Statute. A thorough national accountability process respecting international standards could have a wide-reaching impact in Ugandan society. We believe the robust approach taken in this peace agreement to accountability is an important improvement over past peace accords, and that the pressure brought to bear by the ICC has assisted to achieve this. At the same time, the international community must stand ready to continue its support to the ICC if either side reneges on the agreement. There are many examples of the impact that prosecutions, or even the threat of prosecutions, have in preventing crimes, including war crimes. In Côte d'Ivoire, the prospect of an ICC prosecution of those who used hate speech to instigate and incite to commit international crimes has arguably kept those actors under some level of control. It is also an important example of the possible preventive role of the ICC. In Colombia, the provisions on alternative sentencing and demobilization of the paramilitary groups under the so-called Peace and Justice Law, even as that law was strengthened by Colombia's Constitutional Court, would have left victims with even less prospect of justice for the harms they have suffered if it were not for the need to offer a semblance of compliance with the international standards set forth in the Rome Statute. At the same time, while the peace and justice law shows important innovations, it also shows some of the tremendous challenges in dealing with large number of perpetrators and victims through a system that encourages cooperation with law enforcement and disclosure as an alternative to full-fledged trials. In Darfur, which I visited in 2004 and 2005 in my role as Special Advisor to the Secretary General on the Prevention of Genocide, impunity for earlier crimes, notably for the massacres of 2003 that cost 200,000 lives, has been for too long a factor of instability and a hindrance to prevention of future crimes. That is why early on I joined those who called for a referral of the case to the ICC by the Security Council, a measure of historic significance that was finally adopted on April 1st of 2005. What continues to be essential to the international community strategy is a multi-pronged approach to protection, to humanitarian assistance, to promoting a peaceful settlement of the conflict, and also to criminal accountability. Unfortunately, I have come away with the impression that we were not always strategic or sufficiently persistent in pursuing those four goals. It has now been over 2 years since the Security Council resolution referring the case to the ICC, and the government of Sudan has repeatedly stated that it does not recognize it and that it will not cooperate with the Office of the Prosecutor's investigations or the arrest warrants issued against Mr. Haroun and Mr. Kushaid. In that long period, the Security Council made no effort to remind the government of Sudan that this was a decision adopted under Chapter 7 of the Charter and therefore binding on all states. Instead, we have let the regime get away with defiance of a resolution adopted in furtherance of international peace and security. As far as I can see, only the High Commissioner for Human Rights and my Office of Prevention of Genocide have from time to time raised this point. The result is not only that we do not offer the ICC the support it needs, it is also that we have given away cards that we could have used in negotiating with Khartoum to better protect and assist the 4 million Darfuris who are now totally dependent on international assistance. In the Democratic Republic of Congo, reports of crimes are still surfacing, as for instance the massacre of Kasika. Many crimes are still being committed, particularly against women and girls, in a widespread manner, notably in the Kivus. Thus, the fight against impunity has barely started in this huge country. We hope that the trial of Thomas Lubanga Dilo will soon be followed by other cases so as to give an account of the many horrific crimes committed in this country since 2002. But there is also an acute need in the DRC to foster accountability for the many crimes committed before 2002. It is critical that domestic courts be enabled and empowered to try those responsible, including those bearing the highest level of responsibility. ICTJ is currently co-undertaking a survey so as to better understand the extent to which people have been victimized in the DRC. Another project which will pave the way to fostering accountability in the DRC is being developed by the UN Office of the High Commissioner for Human Rights in cooperation with MONUC, the mission of the United Nations in the DRC. It concerns the mapping of serious violations of international humanitarian law and of massive human rights violations which have taken place in the DRC over the last few years. Such mapping will not only gather and preserve crucial evidence, but also undoubtedly generate a new impetus to advocacy on the need to bring those responsible to justice. The long-term stability of this vast country situated at the heart of Africa is at stake, and much more needs to be done to ensure that the plight of the Congolese is addressed in accountability terms. What all these cases demonstrate is that ultimately the interest of justice and the interest of peace cannot and should not be divorced. Justice is an important component of the prevention of future crimes. It is only through justice and through enforcement of the law that long-term respect for the rule of law can be built. This provides us with an important lesson for all international and hybrid jurisdictions. They must seek more proactively to build their legitimacy in affected regions so as to build their own relevance in the lives of those most affected. Most importantly, these jurisdictions are judged on the basis of their impartiality and professionalism. To be seen as legitimate and respectful of universal standards, there should be no perceptions of selective justice in the prosecutions. Those of us who support these jurisdictions should learn to identify their impact and successes in ways that go beyond the strict confines of the judicial process. In cases such as Cambodia, this will depend on the legitimacy and transparency of the extraordinary chambers in the eyes of both Cambodians who suffered under the Khmer Rouge and the international community. This broader impact is all the more important for those international or hybrid jurisdictions which are being prompted to complete, quote unquote, their work in the coming years. Now is the time to assess their work and also to review their legacy and what remains to be done, with a view to help generate domestic capacity to further their work. Of paramount importance is to bring to justice the leaders, those who bear the greatest responsibility in the commission of international crimes. Even heads of states are not beyond the reach of the law. These principles are reflected throughout international humanitarian law. On the one hand, the principle of command responsibility, and on the other hand, the fact that the official position of individuals does not relieve them of criminal responsibility. Of essential importance, too, is the need to continue to support domestic actors as they seek to bring justice outside of the spotlight of international attention or through the medium of the United Nations. In this respect, I want again to mention important efforts in places such as Chile, Peru, and Argentina. To conclude, the conduct of modern wars affects greater numbers of innocent victims than ever before, and the importance of condemning breaches of international humanitarian law and finding ways to enforce these norms is greater than ever. But one must recognize that preventing violations of international humanitarian law is an ideal which may never be completely attained. Justice, accountability, and punishment play important preventive functions, but they should not be overestimated. The fact that murders have been prosecuted domestically for centuries has not resulted in the cessation of murders, but the fear individuals have of being possibly punished may have a strong psychological impact correlated with the likelihood of being punished. And this may be one of the fundamental problems of international justice. It is not yet systematic, and there are still too many ways to escape it. This in turn shows the importance of the complementarity approach, the need to foster accountability at both the domestic and the international levels so that they ultimately reinforce each other. Situations such as Uganda and Colombia are showing us new ways in which this may be done in the future. Thank you very much for your attention.